the report doesn't appear to address reform of Part 7A, the crisis surveillance provisions, and in my view that fails your principle of laws which are simple, predictable, and
reliable.
Yeah, reliable. Could you please explain whether you looked at Part 7A or?
Margaret, it's fair to say that Part 7A did not loom large in our review, and I think it's probably fair to say neither as a matter of terms of reference nor particularly in submissions that we received as a primary focus. I certainly share your view that Part 7A is important as a matter of price surveillance, but perhaps because it is specialised in the way that it is price surveillance, we didn't see mere reform of the law in that area as important. You will have seen we, of course, did look carefully at the access and pricing regulation aspects of the law because of their particular intrusiveness, of course, into business and into the competitive environment in that sense. And we made a number of recommendations about that, both in terms of Part 3A and the criteria for the application of Part 3A and importantly, the institutional framework for that. But the report has left Part 7A largely untouched and in the hands of the ACCC.
Chris Jones from Herbert Smith Freehills. Let this question not be interpreted as suggesting I'm in any way unenthusiastic and passionately in favour of much of what the panel has recommended. But I am going to ask a question about Section 46. And I'm going to ask a question as a lawyer and not as a commercial person, and I'm not going to focus on uncertainty. What I am going to lament a little bit, as from a lawyer's perspective, is that we so readily dismiss a history of what, frankly, is healthy jurisprudence in Section 46. As Michael rightly points out, in only 40 years we've managed to get 5 High Court cases and a wide divergence of view amongst judges. Now, while that might be suggesting that, well, there's a problem with the law because it creates uncertainty, the reality is, as you try and find the prescription of the special lens that should apply to identify exclusionary conduct and predatory conduct in this area, every jurisdiction has to go through a process of formulating the law. And indeed, you can have wonderful bedside reads, reading the judgments of decisions in Europe and UK and the US, and see a wonderful divergence of views. That is not, I would suggest, a reason to change the law. And indeed, one of the real concerns, and again, expressing this as a lawyer who's very enthusiastic about your recommendations, is in this area is that we seem to accept that we need to keep playing with the statute while we are allowing, or should be allowing, the jurisprudence to develop. And indeed, what we have here is we're just going to create some wonderfully useful times for lawyers, in my position, as we reinvent how this law should be construed in respect of unilateral conduct and market power. And my question to Michael is this, and this is directed to Michael, is that is really on 2 elements of what is proposed. One is that there is a retention of the subjective purpose element. So people talk about this recommendation as being the introduction of an effects test. No, it's the introduction of a new purpose and effects test, or effects test. So why are we retaining a subjective purpose element in a market power provision, and why should we be different to so many other jurisdictions in the retention of that subjective element? And then my other question, which is related, is the absence of the causal connection between the market power and the impact on competition that is in there. And it seems a very big change to the law in respect of unilateral exercising of market power, that we should no longer have that causal connection.
Thank you. Thanks, Chris, for those Two questions. On the first question, why retain the purpose element? I think that's a good question. Indeed, that question is referred to in the final report. It is somewhat ironic the question gets asked given the public debate and people have seen in the press and from the business community, which of course believes that without the purpose limb, the law would be unmanageable and ought to be confined with purpose. But this is the second time a lawyer has asked me, why retain purpose? Shouldn't the test only be effect, the complete opposite of the argument that the business community is raising? I think it's a valid perspective, but my answer is this, Chris, that dual purpose or effect test has been fairly foundational in Australian law since the outset, and of course is found in sections 45 and 47 of the Act and is a foundational principle. So our law has always struck at various forms of business conduct, either on the basis that it has a purpose of substantially lessening competition or it has that effect. You might say that the purpose limb performs something of the role of the law of attempt in American antitrust law. Section 2 of the Sherman Act strikes at monopolisation or attempted monopolisation, and the attempt limb of that is in a sense a preemptive strike at conduct, and the purpose limb, in my view, performs something of the similar role in Australian law and therefore is equivalent to that extent. I still think it does have that work to play. I think it's useful, and certainly having it in section 46 is consistent with the approach in sections 45 and 47. On your second question about the causal connection, which in one sense the take advantage limb performs that role, let me unpack that question a little bit. I think what the question portrays, of course, is an attraction to what we've always seen as this causal connection. You oughtn't to impugn business conduct by a firm with market power unless in some way you can show a causal connection. You can show that the firm is using the market power. In my view, that's the very problem with section 46, because it is a question that is prone to confuse and prone to irrelevance. And let me just, I'll repeat slightly what I was saying about section 46, but let me explain it in this way. So the classical approach to the interpretation of the take advantage limb and using words of causation is to ask, would a firm be likely to engage in the same conduct in a competitive market? That's the sort of classic Queensland Wire test for take advantage. But and for a long time we've all lived with that, and we've all thought it makes some sort of sense because it has some causal connection. But as you pause and contemplate it, you can ask the question, so what? So what that a firm without market power engages in a certain degree of exclusive dealing, wants to appoint certain franchisees or certain retailers as exclusive outlets for that firm. And we often see that in trading. It causes no particular problem. It aligns the producer with the retailer. And if there's no market power, we're not worried about it, and it can produce certain efficiency. But once the firm has market power and engages in that exclusive dealing conduct, it does take on a different connotation. You have the potential to tie up the market, and you have the potential to rigidify the market and exclude new entry. That conduct struck down under section 47, and we have no problem with that. So the analysis we apply under section 47, applying the SLC test, is that conduct engaged in by a firm without market power is benign, we have no problem with it, but engaged in by a firm with market power is not benign and is anti-competitive because the anti-competitive consequences outweigh any particular efficiency benefits from that conduct, and we strike it down. I think it should be struck down under section 46 too, and you just need to then apply it to different examples, including unilateral conduct. So I think the being wedded to a causal connection is wrong economically, and it's a wrong way to approach the competition law issue. And I think the better approach, and which I believe is the approach in the US under US jurisprudence, is the courts have the ability to weigh the efficiency aspects of the conduct as against the exclusionary aspects of the conduct to come to an overall balance as to whether, on balance, this conduct is having substantial anti-competitive effects.
Stephen Croker from Cadence, and sorry Michael, but I've got another section 46 question.
We'll feel that.
Slightly more prosaic question. I'm concerned about section 46 overreach with what's proposed, and in particular overreach in the context of applying section 46 to refusals to supply by dominant players. I can envisage circumstances where it could be illegal for a dominant player to refuse to supply someone even though they're not paying their bills or threatening to not pay their bills. And likewise, I can envisage circumstances where a dominant player could be effectively required by the new provision to facilitate new entry by a competitor. For example, a would-be competitor seeks supply of a business input. Dominant supplier has concerns about the new entrant from safety concerns or something, doesn't want to supply them, but will be effectively forced to facilitate new entry. Do you share any of those concerns?
Stephen, I don't. Whilst I don't want to downplay the importance of that question and the difficulty that refusals to supply throw up from time to time. We know that under the current law. So Queensland Wire, of course, was a refusal to supply case, but the High Court concluded that BHP had broken the law by refusing to supply. Can I say a couple of things about the safeguards associated with it? First of all, of course, the law will only apply if you've got substantial market power, the proposed law. And secondly, the proposed law now will establish, to some extent, a higher standard for competitive harm before it applies. So today, when you're dealing with a refusal to supply scenario, you're judged obviously by the take advantage limb, but also by the purpose test, which is only a purpose of harming a competitor. The proposed test is the SLC test. So the refusal to supply would have to be material, have to be a significant person that you're refusing to supply, so significant that the court is able to reach a conclusion that the overall effect on the market is substantial with this refusal. I really don't have any concerns that if the refusal is for a reason such as someone's refusing to pay their bills, the court would contemplate a case involved relating to harm competition. If they're refusing to pay their bills, competition won't or can't be occurring. It's either because they've got a cash flow problem, they're going to fail, or whatever the reasons may be. But I don't see that as a realistic scenario. And I also believe that if the refusal to supply has a reasonable economic efficiency type basis, that it simply is not efficient to supply, then that won't be caught either. And that's largely akin to the current law. There are enormous difficulties under the current law trying to work out today why it would apply, why it wouldn't apply. But I really don't share your concerns. I think the threshold's high enough that, as I say, that the refusal has to involve a very material occurrence in a market such that you can get to an SLC stage with the refusal.
Why the deadline forcing was removed? Deadline forcing provision.
Yes. Thank you. In the panel's view, and this is a view that's been expressed on a number of occasions over the years, the per se prohibition of third line forcing never really made any sense. So today, what we call second line forcing, a firm supplies a particular product, let me try to think of an example, telecommunications services, on condition that you buy a second product, a mobile phone handset, so a bundled product, is judged by a competition test. It's only unlawful if you substantially lessen competition. Whereas if the same firm engages in exactly the same conduct, save that it says for that second product, the handset, don't buy it from me, buy it from this other person, it's per se illegal. And I don't believe there's any economic rationale for that sort of distinction. And there's often a variety of reasons why businesses are set up in a way such that that's convenient. The proof can also be seen that a few years ago we made third line forcing. We made notification available to third line forcing so that you could get exemption if you put in a notification to the ACCC. After we made that change, hundreds upon hundreds of notifications came forward, and you only need to flick through those notifications over the last 5 or so years to realise how benign, from a competition perspective, all of that conduct is, and really this per se prohibition is a waste of time.
This is another question about third line forcing. I'm old enough to remember as a child my father coming home spitting chips one day because he'd gone to get a mortgage for his house, and he'd been told he couldn't have the mortgage unless he changed insurance companies to one with a more expensive policy, and was found himself forced to do it, classical third line forcing. What I seem to be hearing, in terms of the substantially lessening competition, that sort of behaviour, if you take the instance and try and prosecute it, with no substantial lessening competition. If that becomes a market-wide course of conduct, we see a substantial lessening competition across the entire market. So the real justification for third line forcing is to pick up an area of uncompetitive conduct that wasn't reached by the essentially lessening competition test, making it a per se prohibition. And I see the same thing with the proposal to remove section 4D. Now, am I correct in sort of picking up, it seems to be a strong focus on economics and marketplace effects, where we're missing out on other protections of the consumer and things that the current market, it's the current sort of substantially lessening competition test can't quite reach, but overall is undesirable conduct.
I wouldn't agree with the conclusion, but could I offer these observations? Converting third line forcing to an SLC test brings that form of vertical trading restriction into line with all other vertical trading restrictions. So businesses often engage in vertical trading restrictions. By and large, they're usually to achieve some sort of efficiency benefits. It enables business to align certain aspects of production and delivery of goods and generally lower costs through that process, and it's an outcome of competition. But as for all other areas of vertical restriction, if the practice is widespread, if it's engaged in by the same firm across a market, and the overall effect is to substantially lessen competition, that will be caught by the law. So the example that you gave with third line forcing, making it the same as all other vertical restrictions, all vertical restrictions will be prohibited if in aggregate they substantially lessen competition. There's an aggregation provision in the law under existing section 47, it's under 45 too, that you can rely on. Just one step back from that point is this, that it's broadening the point I made before. One of the economic underpinnings of competition law is the view that our laws ought not to intrude upon trading freedoms unless it can be demonstrated that there are anti-competitive effects. Provided the market is competitive, the working assumption is that businesses will engage in trading practices in order to produce consumer benefits, in other words, to lower their costs and lower their prices, because that is what the force of competition is driving them to. So the bank that wants to tie an insurance policy, by and large, will be seeking to lower prices. The only time that will not occur is when the market becomes concentrated and therefore you exhibit some aspect of market power, monopoly power, and driving prices up. So the test, in the panel's view and in my view, is right, that we oughtn't to intrude on business trading conditions and trading practices by and large unless we can demonstrate harm to competition.
I was interested in the human services increasing competition in that area. I was just interested in the panel's thinking on how to overcome some reservations about competition, particularly in areas like health, where supply constraints are put in place on the basis of quality, and how to perhaps assuage some people's fears in that area.
Yeah, thanks for that. Your name was?
John Cochran.
John, thank you, John. Indeed, this is an area where one needs to proceed cautiously in introducing contestability and choice. And I'd like to think that you'll find the report is very carefully worded for that reason. We believe that there is a great capacity for choice, contestability and diversity to improve the productivity of the provision of human services across the spectrum. And be careful, when I say the word productivity, I don't automatically mean cost reduction. We say nothing about the funding of these services. Productivity also rises, as I'm sure you appreciate, when the value of output rises per unit cost, even if it costs you more. If the value of what you're producing costs even more, increases even more, then productivity has gone up. So the whole purpose here is to try to unleash, if you like, the potential for contestability to facilitate greater innovation, diversity and flexibility in the way these services are provided. But there's no doubt, and we were told by numerous submitters, that, to your point, John, competition faces well-known and significant obstacles in some of these markets, much of which have to do with information, that people can't make effective choices if they have poor information or are incapable of making informed decisions, oftentimes by virtue of their circumstances. In the chapter that deals with this, you'll see us drawing a lot of lessons from experience in Britain in this area about how this might be approached. And what we're really doing is seeking not to be definitive at all, but really to provide an encouragement for the jurisdictions to continue moving in a direction which a number of them, including here in Victoria, but most especially in New South Wales, have already been going. And to help people think about creative ways in which the private sector and the public sector could interact. Interestingly enough, you go across the Commonwealth and you'll see different groups of Australians very familiar with the interaction of the public and private sector in one area and not in another, very supportive of it in one area and then not in another. So our friends, for example, in Western Australia, apart from their desire not to eat imported potatoes, right, or to allow people to buy light bulbs after 5 p.m, they are, on the other hand, completely comfortable with the idea that a large public hospital, and I speak, of course, of the Joondalup Hospital, north of Perth in a major growth corridor, that hospital is run on behalf of the West Australian government, and not just by a private company, but by a multinational public company, I should say, a multinational public company, right? Ramsay run that hospital. And the Western Australians are not just comfortable with that, they think that this is clearly no problem in that at all. And yet you try to talk to them about privatising their electricity distribution network and watch what happens. Now, if you come to Victoria and you try to talk Victorians out of having choice in electricity redistribution, I conjecture there'd be a riot in the street. Right? We're used to making these choices. It's a right. How dare you take that away? And yet if you were to suggest, I conjecture, in Victoria that the Alfred Hospital would be run by Ramsay, you'd probably have a similar demonstration in the street. This is the nice thing about the Federation. We can engage in trials and experiments around the Federation, and different groups of Australians can reach different conclusions. It is true that sometimes these things don't work in particular areas. The Tasmanians made it quite clear to us that you simply can't operate a private market in the delivery of aged care services in certain parts of rural Tasmania. It's impossible. Well, fine. In that instance, the state government would continue to provide and fund the services. This isn't some type of template into which we have to force every practice. It's really encouraging governments around Australia to think creatively about how these things could be done because the rewards are there. Is that helpful, John?
Thank you. I won't stand up and risk shirt fronting you. My question comes from the perspective of one of the cornerstones of the review, which is the encouragement of innovation. One of the ways in which corporations are encouraged to innovate is through the grant of intellectual property rights. It seems to me that the review recommendations seem to expose the enforcement of intellectual property rights now, if the recommendations would be accepted by the government, to much greater scrutiny under competition law. And I wonder to what extent the panel gave consideration to the effects on innovation, potentially the chilling effect on innovation from an intellectual property perspective, if those long-held safeguards in the current Act are removed.
Yeah, thanks for that. Sorry, your name was?
Wayne Condon.
Yeah, Wayne, thanks. Let me answer generally, and then I'll ask Michael to speak specifically to section 51.3. Indeed, Wayne, we actually had a half-day workshop with the Productivity Commission and various other external experts to deal precisely with intellectual property for the reasons that you indicated. I mean, it was impressed upon us, and even if we hadn't worked this out ourselves, it was impressed upon us the sensitivity of the issues with which we were dealing, and the fact, of course, this is well-ploughed ground. That, Wayne, led to the conclusion or recommendation that we would refer, if you like, a detailed inquiry into all of this to the Productivity Commission. Right? It did, however, also result in us exposing, as you say, the potential for trade agreements to conceal implications for intellectual property, which may or may not be in the interests of the Australian public. And notwithstanding, and I would say with due respect to the Trade Minister, who indicates that, well, this might blow away our negotiating position, well, with due respect, Minister, we're about trying to serve the public interest here. Not suggesting the Minister isn't, but I think it might be helpful if people knew what the potential implications were and what we're being asked to sign up to, even now or potentially into the future. But specifically with respect to 51.3, right, let me ask Michael to answer that, because that relates to a narrower area of all of this, as you'll be aware, the specific question of IP rights, as opposed to the whole box and dice of trade protection in IP. Michael.
Thanks, Wayne. I used to have a lot of intellectual property lawyers as friends.
Now he drinks alone.
Yeah. When you used the word enforcement when you started your question, and I'd make this preliminary observation, none of the reforms directly touch decisions to enforce intellectual property rights through the courts. They don't touch the assignment or sale of intellectual property rights, because they're already subject to competition law today, and the reform's not changing that. Decisions refusing to license intellectual property are already fully subject to the competition law, so the reforms don't touch that. So the only thing that 51.3 does, and the recommendation is to abolish 51.3, is to exempt certain conditions in licenses and assignments of intellectual property. So that's the sphere that we're really dealing with in terms of the reform and the abolition of subsection 51.3. So the question becomes on 51.3, and 51.3 has been looked at from time to time in past reviews. But the question for 51.3 is, well, why do we have this special exemption for certain types of conditions in intellectual property licences and assignments. We don't exempt assignments outright, we don't exempt refusals to licence, we don't exempt the enforcement of intellectual property rights through the courts. Why do we exempt these particular licences? And why do we choose this particular form of property and its particular form of exploitation as the proper subject matter of sector-specific exemption? Why do we do that? And we approach that question, and we remark as we approach that question, it's strange that our US friends don't seem to see the need for the same exemption from their antitrust law. And there are many cases that have run through the courts in the US on precisely this issue. And the US courts have found no particular difficulty in wrestling with issues associated with intellectual property. And of course, they generally conclude, and not surprisingly, that if the owner of a particular species of intellectual property right, and let's say it's a patent or copyright, wants to exploit that right through a licence, and wants somebody else to manufacture the product but wishes to impose some conditions associated with that manufacture, whether geographic or whatever, or about the actual product itself that's made, the US courts have no problem in saying, well, that's not a competition law concern. And why do they reach that conclusion? Because they say, well, that right to exploit was held by Party A, the owner of the right, and merely by allowing somebody else to exploit it, but to impose conditions that Party A could have imposed upon themselves, but chose to give the right to somebody else and impose a territorial restriction or whatnot on them, that's not in any manner impeding competition. So that's not a competition law problem. And that's how the matter is resolved in the US quite satisfactorily. Never had a need for 51.3. But I think it is precisely that thinking. There seemed to be a thought process, and I think it runs on to the current day and seems to be held very tight by intellectual property practitioners, that circumstance would cause a problem under competition law. But it won't cause a problem under competition law because it's not harming competition. Then the question becomes, well, why abolish it though? Is it doing any harm? And the problem is, yes, it is potentially doing harm because there are many other types of practice that can be problematic, and that's in the area of cross-licensing and the like, whereby those who have a multitude of potential intellectual property rights and potentially overlapping intellectual property rights can use licences in a sense to gain anti-competitive advantages for themselves. And the view of the panel, and my view, is that those sorts of arrangements ought to be subject to the scrutiny of competition law. So where it is merely the choice to exploit a right through licensing somebody else, I don't think that can ever be a competition law problem, and you don't need the 51.3 exemption. But when you engage in certain other practices, it can be a competition problem, and you oughtn't to be exempted. An analogy I do use, and I know it offends intellectual property practitioners, but very large industrial companies in this country invest billions of dollars in hard assets, railways, ports, and ships and the like. They have no special exemptions from how they commercialise those assets, whether they choose to license the use of them and place restrictions on the use of them in any shape or form. They've spent billions in innovation, capital investment and the like, but they're subject to competition law in their decisions they make about the exploitation of that asset. I can't see myself why intellectual property should have some kind of special exemption. The same way, sure, intellectual property rights are, of course, the creation of a property right to spur investment, just like real property rights are a legal right to spur investment in hard assets as well. But I think both ought to be subject to the competition law, and it won't do any harm, and I think will do some good to remove this exemption.
Can I borrow this?
You may. Don't drop it on your foot.
Unfortunately, we've run out of time. I think it's been a most stimulating day. I hope those of you who wanted to ask your questions have been very satisfied with the answers, and I'm sure that if you do have further questions, our guest speakers will have some time to discuss further with people, maybe. Maybe not. We're all
His
busy.
honour awaits.
True. This is the report we've all been talking about. This is a weighty tome, and it's weighty not only in its size and its weight, but in the scholarship it contains. We've been very privileged to have the chair of the committee and a panellist to address us today. I would like you to join me again in thanking them. And before we do that, I'd like to thank you all for coming. I'd like to thank you for your engagement with the speakers, with the subject matter, for the excellent questions, and I hope you'll come to other events that our centre organises for you. So please join with me in thanking both Professor Harper and Ms. Michael O'Brien.